Our next speaker, I'm very pleased and privileged to introduce John Knox. John was the first independent expert on human rights and the environment, appointed by the Human Rights Council in 2012. That mandate was renewed for another 3-year term in 2015 as Special Rapporteur. He is the Henry C. Lauerman Professor of International Law at Wake Forest University in North Carolina, and teaches and writes on human rights, law, and environmental law. And I don't think any scholar or practitioner of human rights law has done a better job of showing the relationship between human rights and environmental law. And we're very pleased that he accepted our invitation to speak at this event and to share both his understanding and his knowledge and his wisdom and his practical experience in this field with respect to Indigenous peoples and protected areas. So John, thank you, and you have the floor.
If you'd rather have me put back on the little drawing, I can do that now that you've seen what the options are. So thanks again to Professor Williams and the University of Arizona and all the organizers of this conference. Coming this late in the day, I have the risk of repeating things that you've already heard. I've listened to as much as I can of the conference today, and so I'll try to avoid that, but I am going to review a little bit more of the history of fortress conservation before describing an initiative that I'm participating in with the UN Environment Program and a lot of other people to try and clarify the human rights principles applying to conservation organizations. Just to repeat again that the biodiversity crisis that the world faces is also very much a human rights crisis, and in particular a crisis facing Indigenous peoples. I think one particularly telling indication of the cost that Indigenous peoples pay in respect to the effort to protect the natural world is that they suffer more than 1/3 of the 200 deaths of environmental and land defenders killed every year, even though they constitute only 5% of the global population. So you would think then that to be successful, it's kind of obvious that to conserve natural ecosystems, you have to protect the human beings, communities, and peoples who most closely depend on those ecosystems are in the front line of protecting them. However, as you all know, as we've heard in some detail today, for most of the history of international conservation, the advocates of international conservation have ignored Indigenous peoples or treated them as part of the problem and directed their efforts against them. So I want to spend a little bit more time on the dissemination of fortress conservation, and in particular, the role of the major conservation organizations historically in disseminating fortress conservation around the world, before I talk about this initiative that, as I said, I'm working on UNEP with. So Ken Burns, the famous documentarian, has described national parks as America's best idea, quote unquote. Whatever one thinks of the term best in that characterization, it's certainly true that the US vision of fortress conservation became the dominant international model in the 20th century and shaped the creation of protected areas almost everywhere in the world. Australia, Canada, New Zealand, South Africa all created their first national parks in the late 19th century, soon after Yosemite. Sweden created the first European national park in 1909. But obviously the Yosemite Yellowstone model couldn't really have too much traction in countries that had already destroyed most of their natural ecosystems. However, European governments spread the gospel, so to speak, of fortress conservation in their colonial possessions. Indeed, as you've heard, the spread of fortress conservation depended so much on colonial states and colonial attitudes towards the peoples of the global South that you can, with justice, just call it colonial conservation. I want to emphasize a little bit more something Professor Williams referred to, and that's the role of international law in this dissemination. In 1933, European colonial governments adopted a convention that required its parties to select suitable areas in their African territories for national parks and strict natural reserves. This distinction between national parks and nature reserves followed the distinction made in US law between national parks and wilderness reserves. Um, the idea again was to exclude people who already lived there and make it illegal for any kind of permanent structures or communities to remain. Governments in Latin America took a somewhat different approach. They also created many protected areas, but they took a less draconian approach to the indigenous peoples living there. In 1940, a Convention on Nature Protection in the Western Hemisphere also encouraged its parties to create national parks and wildlife reserves, but it defined them in ways that defined those terms in ways that left more room for indigenous peoples' occupation and use. Indigenous peoples in Latin America, of course, I hasten to add, have been dispossessed of their lands for all kinds of reasons, um, arising from economic exploitation and racism, but less often than other places for conservation. By the end of the 20th century, more than 80% of the protected areas in the Latin American and Caribbean region continued to have indigenous residents. In contrast, though, even after independence in the 1940s and 50s, many new governments in Africa and Asia continued to create new protected areas, still following the fortress conservation model. To take just one example, India became independent in 1947. It had only a few wildlife reserves at the time, but 50 years later, they have more than 400 protected areas that covered over 4% of the entire country. In this respect, though, and I think, again, earlier speakers have mentioned this, it's important not to overlook the continuing role of conservationists from the global South. Following in the footsteps of John Muir, they argued not just for the creation of protected areas around the world, but also for the removal of indigenous peoples from those areas. They often acted through and with the support of new private conservation organizations. For example, the International Union for the Conservation of Nature was founded by European and North American conservationists in 1948, and it quickly became an umbrella organization for conservation bodies of all types. Its membership has definitely broadened in more recent years, but in its early decades, it was dominated almost entirely by its members from the global South. And those members persuaded newly independent states, especially in Africa, to maintain existing protected areas and add new ones based on the ideas of fortress conservation. For example, IUCN experts drafted the 1968 African Convention on the Conservation of Nature and Natural Resources, which continued the exclusionary definitions of nature reserves and national parks from the 1933 convention that had been negotiated by the colonial governments. From the 1960s on, a number of other major civil society organizations have joined IUCN in shaping and implementing the international conservation regime. This includes organizations such as World Wildlife Fund, Wildlife Conservation Society, Conservation International, and the Nature Conservancy. They transmit funds, expertise, and values from the global north to the global south. They not only have they urged the creation of new national parks and protected areas, but they've also sought and obtained funding from governmental and private donors in the global north, and then channeled that funding to their preferred projects in the global south. They've also publicized the importance of conservation, thereby promoting further revenue streams through tourism and donations. And perhaps most important, they have advised governments in the global south on how to administer the protected areas once created. Their level of involvement in any particular protected area can vary widely. In some cases, they have provided only technical advice, but in others, at the other extreme, they have partnered with governments to co-manage areas or even administer them directly. The leading organization that specializes in this kind of long-term governance structure is the African Parks Foundation, which enters into agreements with governments that last 20 years or more that basically give it turnkey authority to administer and govern national parks. They kind of fly under the radar, I think, to some degree, at least in the United States, but they are an enormously important organization. At the end of 2021, they were administering 19 national parks in 11 countries in Africa, covering over 57,000 square miles. That's the size of a medium-sized country being administered essentially by one conservation organization. Fiore in her talk talked about the way that the popular image of conservation is shaped, and in particular, these are the organizations that often have historically shaped that image through documentaries, nature guides, calendars, coloring books, stuffed animals, all these products that provide an almost entirely uniform picture of what conservation is and why it's necessary. And as Fiore said and showed, there's images of beautiful landscapes, fascinating creatures, no human beings. Human beings are either completely absent, or if they're identified at all, it's that they're identified as threats. The message, which is often explicit, but is always implicit if it's not explicit, is that to preserve nature, it must be protected from human beings, with no exceptions made, even for the people who have lived in the natural environment for millennia without destroying it. I also want to emphasize, though, that as one of the earlier speakers, or more than one of the earlier speakers have said, it's important to kind of follow the money here. Much of the influence of these organizations has come from their critical role in funneling money for international conservation projects from governments in the global north to the global south. Many donors in the global north, and here I'm talking about private donors as well as public state government donors, are reluctant to provide money directly to governments or other recipients in the global south. And so they prefer or find it more congenial to provide funds to these large conservation organizations. By 2002, the combined revenues of the three largest, at the time that was WWF, the Nature Conservancy, and Conservation International, for their projects in the global south, totaled more than one half of the entire $1.5 billion available for conservation there. In other words, they were serving as a kind of giant funnel through which an enormous amount of money flows towards conservation projects in the global south. Today, of course, the numbers are much higher. Each of the largest conservation organizations effectively controls hundreds of millions of dollars, if not billions, dedicated to conservation. At the same time, the number and coverage of protected areas has grown steadily. By 1980, protected areas just on land covered nearly 9 million square kilometers, which, if it was all in one place, would have been the fifth largest country in the world, about the size of Brazil. Over the next 30 years, that area doubled in size. So now it's a little bit larger than Russia. It would be the largest country in the world. Now, I want to emphasize, not every single new protected area adheres to strict forest conservation by any means, but many of them have, especially in Africa and Asia. A lot of the speakers have already talked about the human rights and ecological criticisms and costs of forest conservation, so I don't really need to dwell on that anymore here. I'll just note that while the exact number of incidents of dispossession is unknown, estimates of those displaced are therefore necessarily approximate, the writer Mark Dowie, in his book Conservation Refugees, states that world estimates range from 5 million to tens of millions of refugees created since Yosemite Valley was gazetted for protection in 1864. And in 2003, another writer, Charles Geisler, estimated that protected areas had displaced, up to that point, over 130 million people. That's just a huge number of people, obviously. And again, it's hard to know the numbers, but it's hard to believe that it's much less than. Again, just a vast quantity of research confirms what should be obvious to anyone. Evicting people from their ancestral lands and denying them access to their sacred sites and material resources has enormous adverse effects on their well-being. Moreover, when displaced indigenous peoples try to return to their ancestral homes to hunt or fish or visit their sacred areas, they're usually treated as criminals. And in many cases, they're physically attacked, unlawfully detained, and even tortured, raped, and murdered. Again, as we've already heard, and I won't dwell on it, even by its own ecological terms, forest conservation has not been a success. From the 1990s on, many studies confirm that it's just extraordinarily difficult for protected areas to be effective if they're created and maintained in opposition to those who have historically lived there. Again, this should not come as a shock to anyone, but nevertheless, it seems to have for many years. This is especially the case, this failure is especially the case in the many countries that don't even have sufficient resources to manage their protected areas. So that, in effect, calling an area a protected area means that it becomes a so-called paper park, a park only on paper, but it's effectively an open access area where the people or entities or companies or business enterprises that have enough resources and clout can come in and use the resources, but the local people's rights are denied. To state again the obvious, for indigenous and community-led protection to be successful, there are many studies that show that indigenous peoples can and have and will do a better job of protecting their ancestral homes, natural ecosystems, better than governments, and certainly far more cost effectively, especially if they have proper levels of support and are not undermined by their governments. But in order to be able to do that, they have to have secure property rights. That's just a fundamental, again, perhaps obvious, but fundamental criterion. That means not just tenure rights, not just formal recognition that this is their land, but they also have rights of access and use, of governance, and perhaps most importantly, of exclusion. They have to be able to keep other people out. They have to have the legal right to keep other people out. So if you put these two critiques of fortress conservation together, the human rights critique and the ecological critique, you see that they really dovetail. And together, they argue very strongly for replacing exclusionary fortress conservation with inclusionary rights-based conservation, regardless of whether that's what indigenous peoples would all call what they're doing. I'm not trying to label all of their practices under the rubric of conservation, a term that many of them, I think, would reject. But my point is, again, just to reinforce what you've already been hearing, the case against fortress conservation was absolutely clearly made at least 2 decades ago. And 2 decades ago, the international conservation regime said, okay, we agree, we reject it. Throughout the 1980s and 90s, the case against fortress conservation had grown. It was reinforced by early drafts of the UN Declaration on the Rights of Indigenous Peoples and ILO 169, which was adopted in 1989. But the moment that you could say the conservation industry, as Professor Williams called it, turned away from fortress conservation on paper was in 2003 at the 5th IUCN World Parks Congress, which was held in Durban, South Africa. Again, the IUCN is an umbrella organization that includes lots and lots of other conservation organizations, as well as government agencies, even academic institutions. At that Congress, the parties to the IUCN explicitly committed to reject fortress conservation as part of an overall conservation strategy called the Durban Action Plan. They set 3 targets, which would be met by 2014. They said that would be the time of the next World Parks Congress. They meet about every decade. The 3 targets. First, all existing and future protected areas will be established and managed in full compliance with the rights of indigenous peoples, including mobile indigenous peoples and local communities. That's number 1. Second, the management of all relevant protected areas involves representatives chosen by indigenous peoples. And third, participatory mechanisms for the restitution of indigenous peoples' traditional lands and territories that were incorporated in protected areas without their free and informed consent will be established and implemented. Well, this sounds great, obviously. We're not going to take indigenous people's lands away from them anymore. We're going to make sure that they have the right to govern the lands that are already created. And where they've been taken away without their consent, then we'll have mechanisms for the restitution of those lands. I don't need to tell you that those things did not happen, right? But I will just emphasize that this was not the only commitment to human rights made around that same time. In 2009, IUCN and 7 of the major conservation organizations, including WWF, launched a Conservation Initiative for Human Rights, the CIHR, and published a conservation and human rights framework whose first principle was to respect internationally proclaimed human rights and make sure that we don't contribute to infringements of human rights while pursuing our mission. And in addition, at the individual level, many conservation organizations, perhaps all of the major ones, have now adopted commitments to respect human rights, including especially the rights of indigenous peoples. This was called a new paradigm for conservation when it was adopted. So, has the international conservation regime, the industrial conservation complex, as Professor Williams called it, has it met that commitment? Well, I mean, To be fair, I would say in some places the answer is a qualified yes. In many countries, tenure rights and forests have been formally transferred to indigenous peoples. And I don't want to lose sight of that because I think it's important to recognize the enormous effort made by the indigenous peoples in those countries to achieve those successes. It's been estimated that states have formally recognized indigenous peoples' collective rights in 269 million hectares in Latin America, which is about 2/3 of the 400 or so million hectares that they occupy. An organization with which many of you are probably familiar, the ICCA Consortium, which is an umbrella organization of indigenous peoples and community-led conservation organizations, regularly issues reports on its members' territories of life, their preferred term for ICCA. So there are certainly some success stories out there. However, despite that, rights-based conservation is still struggling to be accepted in much of the world, especially in Africa, South Asia, and Southeast Asia, as you heard today. I could give many examples, but you've already heard quite a few, and so I think I'm just going to kind of skip that. I do want to just highlight one report I think is really worth your attention, even though it's several years old now. In 2016, the Rainforest Foundation UK published a detailed study of 34 protected areas in 5 countries in the Congo Basin, and it found that indigenous peoples and local communities had virtually no tenure security over their traditional lands in any of those countries, and that of those 34 protected areas, the creation of at least 26 resulted in partial or complete relocation or displacement of local community or of indigenous and farming communities present in the park. So in other words, that's not that long ago. It was a very comprehensive regional report, and it showed that this is a bigger problem than just isolated problems here or there. This is a huge problem globally. To, again, kind of state perhaps the obvious, but just to underline it, many of the parks where these abuses are happening are supported by conservation organizations. Either the organizations are providing funding, or they're providing management, or at minimum, they're providing technical assistance. You heard this morning from Ruben Reyes about the oversight hearing held in October 2021 by the House Committee on Natural Resources, the Subcommittee on Waters, Ocean, and Wildlife. That hearing and the investigation that it was part of resulted from a series of articles by BuzzFeed News starting in March 2019, which described alleged human rights abuses by rangers in protected areas in 6 countries, 4 in Africa and 2 in Asia, all supported by WWF. In 2019, WWF commissioned an independent review panel to review these allegations, and I was one of the 3 members asked to join that panel. It was chaired by Navi Pillay, and the other member besides me was the late Kathy McKinnon, who sadly passed away just last year. I want to emphasize when I talk about this panel report, I'm not speaking on behalf of the panel, which ceased to exist in 2020 when we published the report, so I'm just speaking on my own behalf. I also spoke on my own behalf when I testified at that October 2021 hearing about the report. At that hearing, the WWF representative presented our report as exonerating. And I testified that, in fact, the WWF statement took quotation to the subcommittee, took quotations from the panel report out of context and gave a false impression of the panel's findings. And I expressed my shock, actually, that WWF would portray the report as largely exonerating, when in fact, the panel found that, one, WWF knew, often for many years, about alleged human rights abuses in the parks and protected areas it supports in each of these countries. Second, WWF, nevertheless, continued to provide financial and material support. And third, and most important, WWF often failed to take effective steps to prevent or respond to the abuses. I emphasized one example in particular, which I'll give to you as well, just briefly. WWF has co-managed Salonga National Park in the Democratic Republic of the Congo since 2015. Salonga is the largest land park in Africa. It's about the size of Belgium. WWF appoints the park director and it pays the park rangers. Salonga is a classic example of fortress conservation. When the park was created in the 50s and part of it in the 50s and part of it in 1970, the government expelled the communities that lived there with the exception of a few villages. Those people now live around the outskirts of the park, and it's illegal for them to go back. It's illegal for them to hunt, to fish, to do anything in this vast area. In 2016, a WWF staff member reported internally within WWF that Salonga park rangers were regularly being accused of abusing the local communities. The WWF country director and the WWF park director at the time decided not to investigate because they wanted to avoid conflicts with the government. Only after NGOs made public allegations of abuse did WWF commission independent investigation, which took place in 2019, nearly 3 years after the staff member first raised the alarm. To be clear, this was not our investigation. This was a totally separate investigation. The investigators went to only a few of the hundreds of villages around the park. Nevertheless, they found multiple credible allegations of murder, rape, and torture. In fact, they concluded that rangers were using torture and other cruel and degrading treatment as a regular part of their operation. WWF never published that report. WWF continued to provide financial and material support to the park, and the surrounding communities still don't have access to the park. And as I testified to the committee, I personally believe that pattern is unfortunately typical. WWF has often failed to anticipate or respond to allegations of human rights abuses until the allegations become public. And then WWF characterizes its responses as far more effective than they really are. At that oversight hearing, the chair of the subcommittee, Representative Jared Huffman from California, and I want to emphasize what Ruben Ray said, that the hearing was extremely bipartisan to an extent that it's hard to believe unless you actually watch it. The Republican and the Democratic members of Congress were very much of the same mind on these issues, which is a good thing. It's nice to hear, nice to see that as I won't say, I'm sure you all understand why if you spend any time in the United States in the last 10 years, it's nice to see the Republicans and Democrats actually working together on an issue of such importance. In any event, Jared Huffman criticized the WWF representative for claiming that the panel report had exonerated it. And he pointed out that while she was careful always to refer to the Salonga Eco Gardens as government park rangers, they in fact were paid by WWF. They used equipment bought by WWF. They were operating in a park co-managed and funded by WWF. And WWF senior officials had failed to act on the allegations of abuses. And he asked her, do you believe that WWF bears any responsibility for the abuses that happened in any of the parks that it manages or co-manages? She avoided giving a yes or no answer to that question, which he noted. And then in response to his follow-up question, whether any person had lost their job at WWF as a result of this, she said only that WWF had some new leadership in some places in the Congo Basin, which he construed as a no. He asked, perhaps rhetorically, can you think of any other organization or institution in any walk of life, the corporate world, politics, sports leagues, where horrific abuses happen under their watch and no one loses their job? So the response of the WWF representative to the questioning by Representative Huffman, I think, kind of exemplifies how many actors in the international conservation regime respond to these kinds of abuses. That is, they condemn them. I want to make clear, WWF has never said, oh, the abuses are fine, you're making too big a deal out of it. They'll condemn the abuses, but they take no responsibility for any part of their own role. The agencies and conservation organizations in the global north that support protected areas in the global south instead blame governments in the global south for failing to do a better job of training and overseeing their park rangers. Now, no one disputes that states have the primary obligation under international human rights law to ensure that their officials don't commit murder, torture, arbitrary detention, or any other human rights abuses. But rangers that receive financial and technical support from these conservation organizations in parks that are, in some cases, co-managed by the organizations, do in fact give rise to, at least one feels that they should be understood to give rise to responsibilities on behalf of those organizations as well. Especially in light, and this is why I spent some time on the history, especially in light of the historical role that these conservation organizations have played in disseminating the fortress conservation model that has led to so many of these abuses. So this kind of brings me to the UNEP work, and then I'll try and sum up because I know I've already talked a long time and it's late in the day there. Um, I think a major source of this failure and of the refusal of these actors to take responsibility for their role is their lack of understanding of international human rights law relating to conservation. It's really impossible to replace fortress conservation with rights-based conservation without a clear understanding of what rights-based conservation actually requires. But the international conservation regime has never adopted such an understanding. The commitments that states and conservation organizations have made since the early 2000s to respect human rights and conservation have been vague or non-binding or both. I could give a lot of examples, which I won't in the interest of time, but I'll just note that even the most recent biodiversity plan, the Global Biodiversity Framework, adopted by the CBD Conference of the Parties in 2022, which I'm sure a lot of you are familiar with, it sets 23 targets for 2030, some of which do refer to rights. Probably the most important single target is Target 3, which sets the goal of protecting at least 30% of the planet by 2030. This is the famous 30 by 30 target. That goal, that target, quote, does so, quote, recognizing indigenous and traditional territories where applicable, unquote, and states that the parties should ensure that, quote, any sustainable use where appropriate in those areas or in such areas is fully consistent with conservation outcomes, recognizing and respecting the rights of indigenous peoples and local communities, including over their traditional territories. Now, I think that's a step in the right direction, albeit somewhat of a small step and an overdue step, but it still falls far short of explaining exactly what these rights are and what duties can be expected of conservation organizations, states, and other actors in this area. So I'm working with the UN Environment Program on an initiative, which Francisco referred to this morning, to develop core human rights principles that would apply to conservation organizations and core principles that would apply to conservation funders. I want to be clear about this. I'm not trying to reinvent the wheel. The human rights norms, I think, in this area are actually extremely detailed and clear. UNDRIP does not need to be renegotiated. And if it did, I would not be the person to renegotiate it. I'm obviously, maybe not obvious, but I'm not from an indigenous background. I don't claim to speak on behalf of indigenous peoples. What I am trying to do, though, with, in the context of this UNEP initiative, is to make clear how these existing human rights norms apply to these actors. To that end, we've had a number of rounds of consultation. We had 2 meetings in New York last year in September and December, and we're going to have another meeting in April in New York to bring together indigenous people representatives, conservation organization representatives, rights-based organizations, and conservation funders. And we actually have a lot of support for this. I think there's a feeling that the time is right to get these principles endorsed. I'll just emphasize a few points about them, and then I'll, if people have questions, I'm happy to answer questions. So I just want to emphasize first, the 4 fundamental communal property rights that human rights law absolutely says need to be protected here are, first, the rights of indigenous peoples to have states formally recognize their ownership and possession of the lands that they've traditionally occupied and the natural resources that they've traditionally used. That means not only the resources that are essential for the survival of their way of life, but also those whose extraction will necessarily affect other resources. So even if an indigenous people hasn't had a history of gold mining, say, if gold mining would, as it certainly would, affect their ability to use the other resources, then they still have the right to control whether gold mining happens. That leads me to the second fundamental communal right, which again is one that you're all familiar with, and that's, of course, free, prior, and informed consent. Indigenous peoples have the right to be consulted and to decide whether to consent before actions are taken that may affect them. Third, they have the right, based on their right of self-determination, to govern themselves. That means they have the right to determine their own course of development and the right to autonomy or self-government in matters related to internal and local affairs. The 4th communal property right I want to emphasize here, and I want to make clear, this is not exhaustive. I'm not trying to list all of the rights of indigenous peoples here. I just want to emphasize 4 in particular that are so often violated in this context. The 4th is the right to receive benefits from the use of traditional lands and remedies for lands that have been taken in the past. ILO 169 and UNDRIP both express a preference for restitution of the property taken, but they also both provide that if restitution isn't possible, then the indigenous people should receive compensation in the form of lands, territories, and resources of equal quality, and then failing that, monetary compensation. I want to emphasize here that these norms have not only been contained and set out in UNDRIP and to a large degree in ILO 169, but they're also contained in interpretations of binding treaties, including, for example, the International Covenant on Civil and Political Rights, by the treaty bodies and regional tribunals that are tasked with interpreting those treaties. In other words, UNDRIP is influential not just because of itself, but also because it influences how human rights bodies interpret other binding treaties when they're applying those treaties in the context of indigenous peoples. All right, so that brings me to conservation organizations in particular. How does this apply to them? To make a long story short, the most applicable instrument, I think, in this context is the UN Guiding Principles on Business and Human Rights, which were endorsed by the United Nations Human Rights Council in 2011. Although the UNGPs, as they're fondly or not always so fondly referred to, were developed in the context of for-profit business enterprises, they also have been applied to conservation organizations. They have been applied by they've been applied to WWF, both by a national focal point of the Swiss government in the application of OECD guidelines incorporating the UNGPs, and also by the independent review panel that I served on. The key, there's a lot to be unpacked about the UN Guiding Principles, which I won't try to get into all of it right here. But the nice thing about the UN Guiding Principles is it already addresses in a lot of detail how it is that major non-state actors should be trying to respect human rights. So it goes into some detail about things like human rights due diligence procedures. In particular, it says that the responsibility to respect human rights of these enterprises means they have to avoid causing or contributing to adverse human rights impacts through their own activities, and also seek to prevent or mitigate adverse impacts that are directly linked to their operations, even if they haven't contributed to it. So what does that mean in practice for a conservation organization? Imagine that a conservation organization is administering a protected area, including directing its rangers. This is the African parks kind of situation. Then under the UNGPs, it's responsible for their actions, and it has to be considered to be responsible for any abuses they commit, just as a government would be in that context. Let's say that a bingo or a conservation organization knows about human rights abuses, even though it's not directing the rangers, but it's supporting them. If it continues to provide that support after it finds out about it, after it has grounds to believe that they're committing abuses, then it should be considered to be contributing to the abuses. That triggers the responsibility as well. Finally, let's imagine a conservation organization that is on the far side of the spectrum. It's only providing technical advice. It has really no role in law enforcement. Even there, if it comes to its attention that the government agency or whoever it is that's in charge of the rangers is causing human rights abuses, let's say it's learned that it's instituted a shoot on sight policy or something like that, then it should use all the leverage it can to try and change that policy. And if it can't use that leverage for whatever reason, then it has to seriously consider terminating the relationship, even if it's not causing or contributing to the problem itself. All right, I think I'm going to kind of bring it to an end. I could say more about conservation funders here. I'll just say briefly that in a lot of ways, what we look to is the example of the Advancing Human Rights and International Conservation Act described by Ruben Reyes earlier today, which I think is a good model for what conservation funders generally should be required to do. That is, make sure that before they hand out funds to any recipients, they make sure that those recipients are in fact able to and already complying with human rights. And if they stop complying, then they should cut off their funding, or at least take steps to condition their funding on coming back into compliance. And finally, in that respect, I'll emphasize that the most important step funders should take is to actually provide much more support directly to Indigenous and community-led conservation, which currently receive only a very, very small fraction of all conservation funding. So I'll just kind of close here by saying, I think actors in this conservation regime face a really stark choice today. They can continue down the path that they pursued for more than a century now, which leads both to massive human rights abuses and the continued rapid decline of biodiversity, or they can turn away from that path towards a more sustainable future. I think conservation and human rights rise or fall together, and really the only way to turn away from extinction is to turn towards human rights. So thanks again very much for the opportunity to be with you virtually today. I'm sorry I'm not there in person, and I'm happy to answer any questions.
Great, that was wonderful. Thank you, John. Any questions for John? That was really helpful. Yes. Yes. I'll read them out to you, John.
Or I'm happy.
Okay. Okay. The first, it was one of the works that you cited, Robert Dowry. What was that title of the work called again?
Sure. It's a book by Mark Dowie, D as in dog, O-W-I-E, entitled Conservation Refugees. It's a little bit, it's a little bit old now, 2009, but it's an extremely well-written both history of fortress conservation and chapters that provide, he I guess still is, I don't know him personally, a journalist. And so he's actually traveled to a lot of places around the world, interviewed indigenous peoples, and is describing specific stories as he goes back and forth with the kind of history of fortress conservation. It's really worth reading if you're not familiar with it.
Great, thank you. Next question, rather open-ended, but I'd be interested also in what is your take on co-management?
That is an open-ended question. I mean, co-management with whom, for what, I guess is the question. I think co-management by indigenous peoples and community conservation-led efforts has actually, I think there are examples where that's been super successful. And I think ideally, that's what you would be going for. I think co-management where conservation organizations are co-managing with governments has largely not been successful. I think it's given, there may be some examples of good practices. It's a big world out there, but in my experience, the conservation organizations, it creates a situation where no one has clear responsibility for what happens, right? I mean, that's what you want to avoid. In a situation where there's potential human rights abuses, which is any situation of divergent power, really, you want to have clear lines of accountability and responsibility. And if you have a co-management situation where each party can kind of point to the other and say, well, that was really their fault, that's a really bad outcome.
Great. And then final question coming in on chat and just kind of summarizing it, but it is a good one. And I get asked this question quite a bit. With so many points of entry into the international human rights system, with so many procedures, conferences, ways to influence the UN and the international human rights system, what would be your advice to indigenous peoples, an organization, an NGO? Where do you start to make the most impact?
That is a good question. I guess I'll say two things. One is I don't want to overstate how effective any human rights mechanism at the international level is. I mean, anyone who has spent any time with the international human rights mechanisms knows how weak in many cases they are. When I was a special rapporteur, I mean, I do feel like in some cases I made a difference, in other cases I did not. I mean, despite my best efforts, because governments or the other recipients of my letters or statements or whatever just weren't going to change their ways. So with that caveat, I guess I would say where going to an international mechanism works best is when it's part of a unified strategy that includes the opportunity for domestic advocacy. So if you have a domestic civil society advocacy network and it's working on some kind of change that you want to see or drawing attention to some kind of problem, then it may well be effective to go internationally and use that additional visibility, the additional attention, the additional maybe expertise in some cases you can get from networking internationally. But whether that will work or not, or how well it works in a particular case, will depend on exactly what it is you're trying to do domestically, nearly always. So you need to really think through, what are we trying to get done here, and how would going international help us with that? The mistake I would, not even a mistake, I would just be careful never to assume that going international is going to solve whatever your problem is. It almost will never be able to do that. What it could do, though, is help you provide leverage for whatever changes you're trying to make domestically. That can include going to a special rapporteur, having a special rapporteur issue a communication, having a special rapporteur visit, going to a treaty body, going to the Universal Periodic Review at the Human Rights Council, going to regional bodies, the Inter-American Commissioner Court, the African Commissioner Court. All of those are possibly on the table, but which one would work best in your particular situation is going to depend a lot on the audience, or whatever change it is you're trying to make, and how you see the international effort maybe helping to, again, increase visibility or provide more leverage.
Yeah, excellent answer. We've represented Indigenous clients at IPLP and our International Human Rights Advocacy Workshop. And one of the points that I always make when people say, well, why go to the UN? It's so ineffective, it does nothing. I say, students, the first thing you need to know to get before any UN human rights treaty body or the OAS Inter-American Commission is you have to exhaust your domestic remedies. It's the fact that your own domestic legal system has been ineffective at protecting your rights that you turn literally out of desperation to the last forum that might hear you to bring the types of attention John is talking about. And I remember explaining that to a group of Canadian First Nations, and one of the elders said, so you mean you have to exhaust domestic remedies? Is that yes? He said, I'm totally exhausted bringing remedies against Canada. Thank you very much, Professor. So John, that was really wonderful. Thank you so much for coming in and taking time. I know you're a busy guy, but incredibly helpful.
My pleasure.
Thank you.
Thank you very much. Thanks, everybody.
Okay.